lot of people think that I don't like title insurance or that I think that you shouldn't buy title insurance. That's not true. Title insurance is really important. It's a critical part of any commercial real estate transaction. And I'm going to explain part of why that is in this video. What I don't like is when people misrepresent title insurance as a substitute for a good boundary survey, because I don't think it is that, but it is really important. So if you're buying with a grant deed, why do you need title insurance? So there's 3 types of deeds. We're not going to get super technical. We're not going to go way deep in this video, but you've got your patent, your quitclaim, and your grant deed. So what makes a grant deed different from a patent or a quitclaim? A grant deed comes with a warranty, a legal warranty on the land title. So that's another reason why grant deeds are sometimes called a warranty deed. Okay, so when you buy property with a grant deed, the seller is providing you with a legal guarantee that they have good, clean title to the property that's in the deed. Okay, now there's nuances there. That doesn't mean they're selling you everything that's within the fences, as an example. But what they're saying is they acquired title to what's described in the deed through good means, right? So they have good, clean title. Okay, so in almost all cases, when you're buying commercial real estate, you want the seller to provide you with a grant deed, with a warranty deed or a grant deed. You don't want to buy with a quitclaim. There are certain limited circumstances when a quitclaim deed is okay, but as a general rule, you want to be buying with a grant deed because a grant deed comes with this legal warranty. So let me explain why this is important. So let's just say I'm a toll operator on the Golden Gate Bridge, and you and I I meet you in a bar one night, and you find out that I collect tolls on the Golden Gate Bridge, and I tell you, hey, you know what? I'll sell you the Golden Gate Bridge, and then you can get all the toll money. And you say, wow, how much toll money are we talking about? So I tell you, and you're like, yeah, that sounds like a good deal. What kind of price you make me on the bridge? I tell you $10,000, I'll sell you the bridge. And you say, that sounds like a good investment. All right. So if I sell you a quitclaim deed, if I sell you the Golden Gate Bridge with a quitclaim deed, you're hosed, more than likely, right? If you go to sue me, the judge is going to say, sorry, Landon gave you a quitclaim deed. Okay. But if I sell you the Golden Gate Bridge with a grant deed or a warranty deed and you sue me, the judge is going to say, hey, Landon, you promised this guy, you gave him a warranty, a legal guarantee that you own this bridge. Turns out you don't own it. The state of California owns it. You owe this guy money now. That's the difference between a grant deed and a quitclaim deed. So if a grant deed comes with this legally binding warranty from the seller, why do you need to go get title insurance then, right? You should be covered, right? You've got the guarantee, you've got the legal guarantee that comes with the grant deed. That's not true. So there are still some very important reasons why even with a grant deed, you need to pay for title insurance. Okay, so I'm going to give you a list of those reasons, and I wanted to just point out where this information came from. So there's a really good book. My copy is a little dog-eared, so I apologize, but it's by James, I don't know how you say his last name, James Gosdin, G-O-S-D-I-N is how you spell the last name. It's called Fundamentals of Title Insurance. Excellent book. Highly recommend if you're in commercial real estate that you get a copy. If you're a land surveyor that does boundary surveys, you should absolutely have a copy of this book. Excellent book. So that's where this information comes from. It's in the very first chapter, in fact. So what are some reasons why you still need to pay for title insurance even if you're getting a grant deed? First reason is your seller might go bankrupt. Okay, so I sell you the Golden Gate Bridge, you give me the 10 grand, I go blow it on a vacation in the Bahamas, you sue me when you find out the state of California actually owns the bridge and you're not going to get any toll money. And the judge says, yep, Landon's guilty, he gave you a grant deed, doesn't matter if I don't have money. I tell people all the time, I get threatened with lawsuits on occasion. It doesn't do any good to sue anybody that doesn't have money. So your title insurance company is probably not going to go bankrupt. I'm not going to say that title companies never go bankrupt, but it's highly unlikely that a title company will go bankrupt. One of the reasons is because we regulate title insurance companies, and supposedly the regulator makes sure that the title company is bringing in enough money to remain solvent. Okay, so there is some extra layer of protection if you have a title insurance company. If you're just buying a grant deed from Landon Blake, you have no idea what Landon Blake's financial situation is like. Okay, so that's the first reason. Second reason is title insurance covers problems that are not covered by the grant deed warranty. Okay, I don't want to go into detail in this video, but I'll give you an example. If I give you a grant deed for a parcel, it may still be burdened by easements, right? The warranty in a grant deed doesn't cover those easements as a general rule, but your title insurance will. Okay, so if you buy title insurance and there's an easement that the title insurance company didn't disclose, and it has a major impact on how you can use the property, you can probably go get money from your title insurance company. You're not going to be able to do that with the seller of a grant deed. The other thing is title insurance may cover costs to defend against a claim. That's really important. So if you buy a piece of property and somebody shows up, so I sell you a piece of land, and then 5 years later, my sister shows up and says, hey, Landon sold you that property, but he didn't tell you I owned half of it. You owe me money now for that, my half of the property. That could actually happen, believe it or not. So if you just have a warranty deed, the seller is not required through that warranty as a general rule to pay for you to go to court with my sister. Okay, now if you go to court with my sister and you lose, then you can sue me and go to court and get money from me. But let's say you go to court and the court says, no, Landon's sister never had any right to this property. You're not going to get your court costs, your lawyer fees and court costs back. Okay, but if you buy title insurance, typically, and you have to check the terms of the policy, but typically there is some coverage for the cost to defend against claims by third parties. The warranty in a grant deed may not include historical transactions that the grantor was not aware of. So somebody, let's say Bob owned a parcel and he sold somebody the mineral rights and I didn't know that, and then Bob sells the parcel to me and then I sell it to you with a grant deed, but I never know the mineral rights were severed. You may not be able to come against me to get a claim for the mineral rights depending on what the laws are in your state. So title insurance will typically cover that kind of thing that would not be covered by the warranty in a grant deed. And then a grant deed, depending on the language that's drafted into the deed, may include broad exceptions to the warranty that's included. And so one of the things I mentioned is easements. Usually if you're buying property with a grant deed, there's going to be some exception in there for any easements of record. Okay. And so depending on how the attorneys word the actual deed, you could severely limit the grant deed, the warranty that's provided by a grant deed. Now, title insurance companies can also severely limit the coverage that's in a title insurance policy, but as a general rule, the coverage in a title insurance policy is going to be broader than the coverage in the warranty that's given by a grant deed. So never, ever, ever, ever buy commercial real estate without a good land title insurance policy. Don't rely on the fact that you're getting a grant deed. Even if you're getting a grant deed, you still need to get title insurance coverage for all the reasons that we talked about. We're going to do some more of these videos. Title insurance is really important. You need to understand it if you're involved in commercial real estate. Don't rely on a grant deed. Get title insurance for your purchase.